Hello students, welcome to Ekam IAS Academy. This is an article in the Hindu newspaper on the 18th of April 2023. This article is about certain petitions filed in the Supreme Court related to same-sex marriages. See, very important from the governance perspective, very important from the social issues perspective. So this particular article is primarily important from the mains perspective point of view. See, try to understand. See, when we talk about any issue which is futuristic, like in the past also, Supreme Court has given decision related to section 377 of the IPC, if you remember. In the past, the Supreme Court has also spoken about the marriage as an individual choice. If you remember the famous Hadiya case of Kerala 2017, I'll throw some light on that particular issue as well. Try to understand, whenever these issues come to the Supreme Court, as a matter of fact, understand that the society is demanding some change. So that is how this society is trying to make some influence on the judiciary and also on the other institutions of the government, that the society is demanding a change. However, in this particular case, when it comes to the government, the institutions run by the government, and also the religious institutions, some of the foundations spread across all the religions, Hinduism, what you call Muslim, and also Christianity, they are all talking against this particular thing. So, will the government be able to travel across these differing views and give a landmark judgment today or not is going to be seen. One more very interesting fact, gentlemen. 2017 Hadiya case, the famous Hadiya case, where a girl converted to Islam and married a Muslim boy. This particular case was annulled when it came to the Kerala High Court. The Kerala High Court annulled the marriage because it said that the conversion happened purely for the reason of marriage. But Supreme Court set aside that judgment and gave all the protection possible to this girl who got married to a Muslim boy after getting converted. Why it is interesting is, in that same case, our present Chief Justice of India, Y. Chandrachud, was also one of the bench members. It was a 3-judge bench of the Supreme Court, not a constitutional bench, just a 3-judge bench. So this particular news again gets that significance because Y. Chandrachud, the Chief Justice of India now, is known to be very futuristic and very pragmatic person. So will all his pragmatism, his learning, his futuristic ideology will help him to go against all these people who are against this particular issue and give a landmark judgment or not? Many such issues I will discuss in this particular article. Students, I am Major Sps Oberoi, one of the faculties and mentors at Ekam IAS Academy. Before we go ahead with this article, I request my students not to forget to subscribe to our YouTube channel for more such videos on current issues which are important, very, very important from the UPSC as well as other state PCS examinations. Go ahead. The same-sex marriage, why it is in the news. As I told you, on 18th of April, that is today, a 5-judge Supreme Court bench. The moment it is a 5-judge bench, as we all know, it is a constitutional bench. Okay? It is a constitutional bench. Headed by the Chief Justice of India, Y. Chandrachud, is scheduled to hear a series of petitions seeking legal recognition of the same-sex marriage, even as a host of statutory organizations, religious bodies and NGOs have rushed to the court seeking an opportunity to be heard. It means that all of them are against this proposal of legalizing the same-sex marriage. See, understand that in India, presently, the same-sex marriage is not legal. It does not get any legal recognition. So their submissions touch upon various issues from the definition of marriage to the psychological impact growing up with 2 men or 2 women as parents would have on the children. This is where the religious institutions and NGOs want to talk to the Supreme Court. While some have cautioned the judges that Indian society is not ready to accept the same-sex marriage, others have linked it to the sexual liberation movements in the Western countries. So, people from across different cultures and societies are trying to give their opinion to the Supreme Court related to the issue of same-sex marriage. Okay. Now, what is the petitioners' argument? The petitioners who are fighting for this cause, what do they say? The petitioners argue that the non-recognition of the same-sex marriage amounted to discrimination that stuck at the root of dignity and self-fulfillment of LGBTQIA plus community. What it says that the non-recognition of marriage, it stuck at the root of dignity and the self-fulfillment of a particular sect of community. And this particular petitioners also tell the Supreme Court that they reminded the court that the LGBTQ plus citizens form 7 to 8% of the population of the country. They are only trying to elevate the problem, saying that it is a matter of 8% of population of our country. So it is not that only 1, 2 or 3 people. It is 8% of your populations. The petitioners point out that the legal protection available in about 15 legislations guaranteeing the right to wages, gratuity, adoption, surrogacy, etc. were not available to this particular citizens. So it means to say that not only issues related to marriage, various other statutory provisions which are available to the other citizens, they are not available to these community people. There are certain institutions who have spoken for and against. Let's see. The Delhi Commission for Protection of Child Rights. What is the view of this institution? Probably this is the only institution that has spoken positive about this particular same-sex marriage. What it says? The Delhi Commission for Protection of Child Rights said the same-sex couples would make equally good parents as heterosexual parents. So, one positive dimension. By depriving legal status to homosexual marriages, the state is denying the legal security of dual parenthood and guardianship to the child. Since the Netherlands legislation of same-sex marriage in 2000, over 34 countries have legalized same-sex marriages either through legislation or through court decisions. It also says that at present, more than 50 countries allow same-sex couples to legally adopt children. Let me tell you students, in India, adoption by same-sex couples is not permitted. So it says that at present, more than 50 countries allow adoption to legally adopting the children to same-sex couples. A 2020 study by the American Sociological Review show that academic results of children raised by the same-sex parents from birth outperformed children with heterosexual parents. It means the social environment plays an important role here and not the genetics. That's what they want to showcase here. So very, very positive approach towards this particular issue by an institution called the Delhi Commission for the Protection of Child Rights. This is one institution that has played very important role in protecting the children and their rights. Please do also Google about this institution from your prelims perspective. Now, very important, the stand of the government. What is the stand of the government? The union government has said that the idea of same-sex marriage is merely an urban elitist view, not very sounding, not very pleasing to listen. It says that it is just an urban elitist view. The acceptance of this same-sex marriage in rural area and also in the middle class families in the urban clusters will not get that social sanctity. This is what is the government trying to say. The judicial creation of a new social institution like same-sex marriage cannot be claimed as a matter of right. Very important. It is saying judicial creation. In a way, indirectly, the government is saying that the judiciary is trying to overreach on the legislative function. The government is saying, if anything has to be done on this particular issue, I will bring in a law, I will introduce a bill. It cannot be done through a judicial creation. It is the parliament and not the courts that have to decide on the same-sex marriages, which is a threat to the holy union of marriage between a biological man and a woman in India. See, one thing that you need to understand here is holy union. See, as per the Indian culture and tradition, marriage is a sacred institution where the divine blessing is sought as in the process of the marriage. So that is how the government is trying to say that it is a holy union, a sacred union between a biological man and a biological woman in India, and this cannot be touched upon even by the Supreme Court. So a very negative in the sense opposing view. I am not saying that the government is negative, it is an opposition view, that the government is opposing to the idea of the same-sex marriage. Okay? Then the National Commission for Protection of Child Rights, another institution. It says that the National Commission for Protection of Child Rights, unlike its Delhi counterpart, argued that the same-sex marriage would violate the provisions of the Juvenile Justice Act. Very, very important. Why? Because it says that the Juvenile Justice Act prohibits a single man, let alone two men, from adopting a girl child. So already the Juvenile Justice Act is prohibiting even a single man to adopt a girl child. So the National Commission for Protection of Child Rights highlighted a study by the Catholic University of America, which said that the emotional problems suffered by children of same-sex couples were twice more than of children living with heterogeneous parents. It said a proper legislative system needs to be adopted regarding the same-sex couples. So, it says that the Catholic University of America. Now, but you have to understand the Catholic University of America, anything which has got a Catholic stamp, it will always have a deontological approach. What is a deontological approach? Where the ethical values of religion cannot be changed because of the present contemporary times calling for that change. So they have a very fixed approach called deontological approach. They do not accept any changes in the religious ethical belief systems. So, and this particular institution is against and says that it has founded that the children with the same couples as their parents suffered twice more than the children with heterogeneous parents when it comes to emotional problems. Okay? Now, the religious bodies view, the four religious bodies that the government took a view, the Sri Sanatan Dharma Pratinidhi Sabha, Jamaat Ulema-e-Hind and Markazi Shia Ulema Council and Akhil Bharatiya Sant Samiti. All these four institutions are opposing the same-sex marriage. That's what they say. It reiterated that the same-sex marriage is totally unnatural. Okay? It says that the marriage between opposite sexes is like the basic feature of marriage. Belonging to an opposite sex is the basic feature of marriage that cannot be changed. So the religious bodies are completely against this same-sex marriage. They are not supporting the same-sex marriage in any way. They say that the concept of same-sex marriage is catastrophic and that it would have a pernicious effect on Indian culture and society. Very strong statements by them, strongly opposing even the thought of the same-sex marriage, let aside legalizing it. What are the NGOs talking about it? An NGO by name Kanchan Foundation and also an NGO by name Call for Justice NGO. What they say, it submitted a deep-seated stereotype and mental barriers that have been constructed over centuries cannot be dismantled by a mere judicial ruling. It says that Indian society requires more time to be sensitized in order to accept the same sex unions and understand their impact on the society. It says that even if the Supreme Court brings in a law legalizing the same sex marriage, it would be very rare and very stray incidents of a couple getting married, but the society at large will not be accepting it because the stereotypes around it are so deep rooted that India will take long time to accept this as a sacred institution. As I told you, marriage being a sacred institution, that sacred character in the union of two men or two women will not be there. It would be missing. The sacred character of the institution as a marriage would be missing. And what is the call for justice NGO saying? It argues that marriage flows from the natural law and the millennia-old institution of marriage between a man and a woman is recognized across the world. Any amendments in the institution of marriage must flow from popular will as expressed through the legislature. So this particular institution, because the popular will of the people is expressed by the government. So let the government bring in a bill in the parliament and let that bill get the sanctity. The moment the bill gets sanctity, that in that scenario I would accept the legalizing of the same-sex marriage, but it should not be through the legal route. It cannot be through the judicial route, what this particular NGO is talking about. A cisgender view. Cisgender view is a person whosoever is identified as man during birth continues to recognize himself as a man. He is called a cisgender person. Sam Thomas, who introduced himself as a retired cisgender male engineer, said laws regarding marriage must not be changed to accommodate the insubstantial concept of same gender or gender neutral spouses, since marriage is substantially male-female sexual intercourse of a singular kind. So he is bringing in the dimension of sexual intercourse as at the core of the marriage. Sexual intercourse at the core of the marriage. And he also says that, one more important dimension, he also says that importance to conception, and this sexual intercourse is basically with the primal intention to have a progeny. So in the case of a same-sex marriage where two men or two women are marrying each other, the sexual intercourse cannot result in conception. So he says that a man, a woman sexual intercourse was in a category of its own. The necessary condition for marriage is one man, one woman sexual intercourse with the possibility of simultaneous climax through stimulation of and by the sexual organs alone. So very important, he is talking about the role of sexual organs in the conception in a marital relationship. He says that the sexual intercourse being at the core of the marriage with an intention to progeny, the genitals, these sexual organs play an important role here. So because two men or two women marrying, it can never lead to a conception. In that sense, the idea of marriage is completely ruled out. And he goes on to say that, and no other limbs or artifices. So if you are using any other body part as part of your sexual intercourse, then it is only meant for seeking pleasure and not progeny. And it cannot be supported. An excellent argument put across by this senior person who is a retired cisgender male engineer. Okay. Now, the famous Hadiya case I told you in 2017. She is the one I spoke about, Hadiya, a girl who got converted to Islam and married a Muslim boy. So the Kerala High Court had annulled this particular marriage in 2017. The choice of a partner, what the court said, these are the words of Y. Chandrachud in 2017. The choice of a partner, whether within or outside marriage, lies within the exclusive domain of each individual. Intimacies of marriage lie within a core zone of privacy which is inviolable. So he basically brought in the Article 21 here, that the right to life and personal liberty within its internal core also has the right to choose the person of your choice for marriage, and the faith cannot be a dominating factor of choosing your partner. The absolute right of an individual to choose a life partner is not in the least affected by matters of faith. The Constitution guarantees to each individual the right freely to practice, profess, and propagate any religion. The choices of faith and belief, as indeed choices in the matters of marriage, lie within an area where individual autonomy is supreme. Nobody can enter that zone. Neither the state nor the law, neither the state, that is the government, nor the law can dictate a choice of partners or limit the free ability of every person to decide on these matters. They form the essence of personal liberty under Constitution, that is Article 21. These were the words of our present Chief Justice of India, Y. Chandrachud, in a very famous case of Kerala in 2017. So with this backdrop, now we need to see what will be the possible outcome on this case in the hearing in Supreme Court today. At present, the petitioners themselves and the Delhi Commission for Protection of Child Rights are the only two entities opining the granting of legal status to the same-sex marriage in India. Others are not supporting it whatsoever. The government's opposition, the religious institutions and various bodies, along with the NGOs objecting the same, has created the challenge in front of India. So in this backdrop, we will have to wait and see whether the societal norms win over the individual or the individual choices, the individual freedom to choose the life partner prevail. So that is where the question of whether it is an individualism that will survive over the societal norms. So very important legislation. If this happens, it is going to be written in red letters in the history of India's societal context, that a legislation brought in a change in a social norm that is acceptable in the society. So this is all about this news. For more such news and current affairs issues to be evaluated in depth, I request the students to subscribe to our YouTube channel. Thank you. Signing off, your instructor, Major Sps Oberoi. Jai Hind.